Amazon Apex. So for my friends who are selling on Amazon, if you received an email from Amazon inviting you to participate in Apex, I'm going to walk you through what it is and whether or not you should follow through. So Apex is a patent dispute program that's started by Amazon for resolving utility patent cases. And in other words, if your listing has been accused of violating a utility patent, the patent owner has filed a claim against you, and Amazon has agreed to allow the parties to go through this program, and they will select an independent evaluators, often an attorney, who will make a final decision on whether or not your product listing violates the utility patent and should be taken off, or whether you can continue selling. So the first thing you want to do if you're an accused seller and you got this invitation for Apex, you want to do a cost benefit analysis to see if it's worth spending the 20 to 30K of attorney's fees to defend an Apex case. If you're not selling enough, it's just not worth it to do this. If you are selling enough and you think that this is worthwhile, then you're going to want to have a preliminary analysis done to see if you've got some decent non-infringement arguments. Keep in mind that in Apex, you can't really challenge the validity of the patent unless it's your own sales that were made 1 year before the effective filing date of the patent. So you can't use third-party sales, you can't use prior art to try to say that, oh, this patent is invalid and they should not have got this patent in the first place. If you feel like you want to move forward, then you've got to make sure you sign that evaluator agreement, get it back to Amazon within their deadline, which is usually just a few weeks from the time that they sent you that initial email. And then each side has to pay an evaluator deposit, which as of now is $4K. The winner gets their $4,000 evaluator deposit back. And this is just for the evaluator. This is not covering the attorney's fees that will, for the patent attorneys who will be fighting for you to try to win this case. The evaluator will set a briefing schedule. Patent owner always goes first. You, the accused seller, will have one opportunity to file a response brief. You can also have a claim chart. And so with our claim charts, we like to show the claim feature, a drawing from the patent to show as an example of what that claim feature looks like. And then we put some photos of the accused product from strategic angles and with annotations. You know, we point to certain parts of the product, say why that claim feature is missing from your product. So in addition to the response brief, which is limited to only 15 pages, you get to have this claim chart that helps the evaluator visualize why your product does not infringe the patent. After your response brief, the patent owner has the option to file a reply, and they often take it because they get the last word, and so they want to take that opportunity to get the last word. You as the accused seller do not get to file another reply. So again, your best arguments need to go in your response brief. After the briefing schedule is done, the evaluator will make a decision. If the evaluator finds that your listing is likely not to infringe, that means you win, you get your 4K deposit back, and your listing stays on Amazon and you get to continue selling. If you lose, your listings will be removed from Amazon. I hope this is helpful. We'll talk more about some strategies of whether or not to go through Apex and what you can do to challenge the patent in another video. I'll see you in the next video. Thanks, bye.